Good morning, everyone. This is Tripp VanderWal, a member of our Miller Johnson Employee Benefits and Executive Compensation Practice. Thank you for joining our webinar this morning, our daily or COVID-19 webinar. And today we will be focusing on the newly passed American Rescue Plan Act of 2021. But specifically the COBRA subsidy, ACA premium expansion, and dependent care FSA implications under that act. Now that it's 8 o'clock, we will get started. As I think most of you are probably aware, you can submit questions through the question and answer feature. I will try to take those up as I see them. Otherwise, I'll try to save a few minutes at the end of the presentation to address those. One thing that I should point out is that the American Rescue Plan Act, or ARPA, is not technically law yet today. It was passed by the Senate this past Saturday and passed by the House yesterday. It is being presented to President Biden, and it is expected that there will be a signing ceremony, or it will be signed at some point tomorrow. So please do realize that this law is not in effect yet, but we think its effectiveness is imminent as soon as and expected to be tomorrow. Moving right along, let's start off with probably the biggest impact under ARPA on employee benefit plans, and that's specifically group health plans, and that's COBRA premium subsidies. I'd like to point out before we get into this in any more depth that for those of you that were around doing this or dealing with these issues back in the Great Recession, you may be familiar that the American Recovery and Reinvestment Act of 2009 also contained a COBRA premium subsidy provision. And the good news is that the law in ARPA that is just passed yesterday, or will be signed tomorrow, is very similar to that previous 2009 legislation. So to the extent that you can kind of remember what you went through back then, I think the experience is going to be very similar. The other helpful part about that is while we wait for additional guidance on how these COBRA premium subsidies are going to work from the IRS, the Department of Labor, we can look back and I think glean some guidance from the IRS DOL guidance that they issued back in 2009 under the previous legislation. Specifically, I spent some time over the past couple of days reviewing IRS Notice 2009-29. You can probably find that just using Google, and it is a series of question and answers which I found quite helpful. Keep in mind, again, I think you should just try to use that to set expectations. The departments will issue additional guidance on how the COBRA premium subsidies are going to work under ARPA, which is will be the current law, and there are some pretty important differences. One notably is the amount of the premium subsidy or the COBRA premium assistance. So under ARPA, assistance eligible individuals will be eligible for premium assistance for COBRA coverage beginning April 1, 2021. And we'll talk about how long that COBRA assistance will last here in a second. But I think first is important is to understand who exactly is an assistance eligible individual. And that is any individual who became a qualified beneficiary, a COBRA qualified beneficiary, due to losing coverage as the result of an involuntary termination of employment or a reduction of hours. It does not include anybody else that became a qualified beneficiary because of other COBRA qualifying events, such as lost coverage due to death of an employee, divorce or legal separation, in the rare instances Medicare eligibility that applies, or ceasing to be a dependent. It also does not apply if you voluntarily terminate employment with your employer. Again, going back to IRS Notice 2009-29, there are a series of FAQs addressed that when is a termination voluntary and when is a termination involuntary. And I think, the good news is primarily I think that's going to be relatively straightforward. But as you can see, if you take a look at those Q&As, there can be situations where it becomes a little dicey or you're in a gray area. Next is how much is the assistance? And it's actually 100% of the COBRA premium. So these qualified beneficiaries will be able to elect COBRA for a certain time period at no cost. And this was actually a big difference between the bill that originally passed the House and the Senate bill. The bill that originally passed the House, the COBRA subsidy was only 85% of the COBRA premium, meaning that COBRA qualified beneficiaries would still be required to pay at least 15%. And the Senate version, which then passed the House and is now on its way to President Biden for signature, increased that subsidy to 100%. So a couple of questions that come up is for those of you that are familiar with COBRA, is when we administer COBRA, we're able to charge actually up to 102% of the applicable premium. And so does the subsidy offset the 2% administrative fee as well, or the qualified beneficiary still need to pay that? Well, the legislation is not actually clear on this issue, but again, if you go back to that previous IRS guidance for when we did this, after the Great Recession, the IRS indicated that the 2% fee was included, and so that would be included in the COBRA premium. Therefore, the COBRA qualified beneficiary would also not have to pay that 2% administrative fee. One thing to note that if you are providing some form of subsidized COBRA, so let's say you have someone that involuntarily terminated employment, and you decided to, as an employer, subsidize the employee's COBRA premium, so that they were, continued to pay, the same price that they would as an active employee for a certain period of time, the 100% premium is only going to apply to the cost that the qualified beneficiary has to pay. The COBRA premium is not going to apply to the employer contribution, and that becomes not only important for, that may be irrelevant to the qualified beneficiary who's essentially going to get free COBRA anyway, but when it comes to the entity that is funding, which we'll talk about, that COBRA premium assistance, it is going to become relevant when applying for a tax credit to offset the amount of those premium subsidies. And finally, if there's any payment that the qualified beneficiary does pay during this period that they were entitled to 100% COBRA premium assistance or free COBRA, the law does dictate that amount must be reimbursed to the qualified beneficiary. One other thing I think I forgot to mention is that this doesn't apply to continuation coverage, not only the federal COBRA, but comparative state laws. So if you are an employer that maybe is not subject to federal COBRA, but you operate in a state which is not Michigan that has a state COBRA law, and you provide continuation coverage, as long as that state continuation law is similar or is comparable to federal COBRA, this premium assistance subsidies are still going to apply, and you're still going to be eligible for a tax credit for providing those premium assistance subsidies. So how long will the COBRA premium assistance or the subsidy last? And it's scheduled to end for everybody currently on September 30 of 2021, so later this year, unless of course that date is extended by future legislation. The premium assistance can also end earlier than that date based on an individual's particular circumstances. So it ends upon becoming eligible for another group health plan, and that it's important that I highlight eligible there, not necessarily enrollment. So if I become eligible for another health plan, whether it be because of a new job or because of through my spouse's employer, but I waive that coverage, I'm going to cease being eligible for the COBRA premium assistance because I only have to be eligible for that other group health plan. And that also would not apply during any waiting period under coverage under that group health plan. For this purpose, a group health plan does not include accepted benefits, so dental or vision only benefits, medical FSAs, or a QSERA, Qualified Small Employer Health Reimbursement Arrangement. You also will cease to be eligible for the COBRA premium assistance upon becoming eligible for Medicare. And when you become eligible for a group health plan or Medicare, you as the qualified beneficiary have to notify the group health plan providing the COBRA coverage of your eligibility. If you fail to provide that notification, you could be subject to a $250 fine, or if you intentionally fail to provide that notification, it could be up to 110% of the amount of premium assistance that you receive. And there is, importantly, an exception for a reasonable cause. So if there's some reasonable cause that I failed to give that notice, that penalty will not apply. Finally, the COBRA premium assistance is also going to end whenever the normal exhaustion of the COBRA premium, whenever the COBRA premium would have otherwise ended. So who's gonna pay for these COBRA premium assistance subsidies or this COBRA premium assistance? Ultimately, it will be the federal government that pays the bill for this premium assistance, but it's going to have to be funded, at least initially, by private parties. So the way that this breaks down is the plan sponsor of a self-funded plan is ultimately going to have to front, if you will, the money for this COBRA premium assistance, and the plan sponsor of that self-funded plan will be eligible to offset from its Medicare tax an amount equal to the assistance that it provides. In a fully insured group health plan arrangement, it's the insurer that has to front this COBRA premium assistance, and the insurer in that case will be eligible for the credit against the insurer's Medicare tax. In the multi-employer or union Taft-Hartley plans, these are also called, context, it will be the multi-employer plan that has to fund the COBRA subsidies, and will be eligible for the tax credit on the union plan's Medicare tax going forward. So not only is this law, basically giving a limited time period of free COBRA to people, it is actually giving some other options, which we'll kind of walk through here. And one is the ability to change your current COBRA coverage option under a group health plan. So if you are an assistance eligible individual, so again, someone who lost coverage and became a qualified beneficiary due to your involuntary termination of employment or reduction in hours, and the employer permits you to change coverage options, you will have the ability to change coverage options within 90 days of getting a subsequent notice, which we will talk about later. But again, that is only allowed if the employer permits the change. The employer is not required to permit that change. The premium amount under the other or new coverage option doesn't exceed the premium amount under the current coverage option. So you can't basically say, hey, I get free COBRA, and I elected kind of the cheapest plan that my employer offers, and they offer kind of a Cadillac plan. So that's free, I'm going to switch to that. Can't do that. You can switch to a coverage option that is the same COBRA premium or cheaper, but you can't switch to more expensive coverage. The other coverage option has to be offered to other similarly situated non-qualified beneficiaries or active employees, and the other coverage option cannot be an accepted benefit, a QSERA, or a medical FSA, medical flexible spending account. So the other issue that is addressed in this legislation is what I call second bite at the apple, and really that is the second chance for certain people to elect COBRA coverage. So beginning April 1, 2021, and ending 60 days after the individual received the revised notice, or the notice that we'll talk about here in a minute, certain individuals have the opportunity to elect COBRA. And those individuals are, again, an assistance eligible individual who has not elected COBRA as of April 1, 2021. So again, that would be someone who became a COBRA qualified beneficiary due to an involuntary termination or reduction in hours. Or, as it appears, any individual who had previously elected COBRA but terminated COBRA before April 1, 2021. So again, the second one is if I had previously elected COBRA, for some reason maybe I thought it was too expensive and I terminated it, I have the opportunity to elect it again, within 60 days of receiving this notice. But that's not necessarily going to make me an assistance eligible individual, so I may still have to pay for that COBRA if I elect it. If you make an election under the second bite of the apple rule, the coverage is effective for the first period beginning on or after April 1, 2021. So, if I have been sitting kind of in this COBRA election period for a number of months and I elect under this, provision under ARPA, my coverage is not going to be retroactive back to the date that I lost. It's only, which we'll talk about here in a minute. It's only going to be retroactive back to April 1, and if you're an eligible assistance eligible individual, it's going to be free COBRA. And then the COBRA coverage will terminate as though it would have originally terminated under the original COBRA duration rules. So what I think is interesting, what we didn't deal with back in 2009 with the American Recovery Act is we didn't have this, this guidance from the Department of Labor and IRS that basically extended certain COBRA election or COBRA deadlines, which would include the time period to elect and pay for COBRA during the outbreak period. And for those of you that attended our webinar on Monday morning, we got additional guidance from the DOL. It says that those extensions are basically going to last till the end of the outbreak period, which is 60 days after the presidentially declared national emergency for COVID ends, which we don't know is going to happen, or 1 year after the original deadline. So I think the big question is here is how is particularly these COBRA premium subsidies going to interact with the DOL guidance under EBSA disaster relief, these disaster relief notices. So I think presumably if you are one of these individuals who maybe had experienced involuntary terminated employment last August, you haven't elected COBRA, but under this disaster relief notice, you're still eligible to elect COBRA because that COBRA election deadline has been extended for at least a year. What does that mean? And I would say, well, it seems like you may have two options. If you elect under ARPA, the second bite at the apple exception, your COBRA is going to be retroactive to April 1, but you're not going to have to pay for any of that COBRA. Alternatively, I think you could actually make a normal COBRA election, which would be retroactive back to the date that you originally lost coverage. But of course, any COBRA coverage provided before April 1, 2021, you would need to pay for. I think the other question, it may be relatively elementary, is we have certain deadlines that apply under this new ARPA legislation. Does the disaster relief extension of deadlines apply to those deadlines under this new ARPA legislation? Are we just rolling this kind of all into the bundle here? And I think additional guidance from the DOL and IRS would be helpful. And I am optimistic that we will get some. It will just be, it's unclear how fast we'll get that. For those of you that are familiar with the EBSA Disaster Relief Notice 2020-01, we were running up on March 1 trying to figure out how we're going to treat these extended deadline periods because arguably the extension ended on February 28. The Department of Labor released Disaster Relief Notice 2021-01 on Saturday, February 27. So it gave you a whole day to figure this out, which was also over the weekend. So, of course, with all of these new opportunities under COBRA, we have sort of revised COBRA election notice obligations, which we're going to kind of walk through here. The good news is the departments are supposed to issue model notices, which I think will provide a lot of help on what some of this means. So ultimately, for COBRA election notices that are delivered between the period of April 1, 2021 and September 30, 2021, unless it's further extended, the COBRA election notice must include clear and understandable language about the availability of premium assistance or the COBRA subsidy. And if the employer permits, the ability for the individual to enroll in a different coverage option under the group health plan. The legislation says that this information can be provided in the actual election notice, so you can revise or amend your current election notice, or you can provide it by a second document as long as that separate document is delivered to the qualified beneficiary along with the election notice. There's also this alternative notice requirement. This wasn't entirely clear to me what this was getting at until I reviewed the DOL's previous guidance on, for these COBRA subsidies after the Great Recession. But it basically appears that the Department of Labor, IRS, and HHS will issue additional guidance, maybe even model notices, that must be sent to participants in fully insured group health plans not subject to COBRA, who become eligible for COBRA coverage under state law that is comparable to COBRA. So remember at the beginning, I made a point to state that these COBRA subsidies are not only going to apply to plans that are subject to federal COBRA, they're also going to apply to those smaller plans, maybe not subject to COBRA because they have less than 20 employees, but maybe subject under state law. Again, if you're operating only in Michigan, we don't have a state continuation law, so it's not going to apply to you. It appears that this is where that alternative notice requirement. Finally, both of these notices are going to have some additional content, which are forms necessary for establishing eligibility for premium assistance. Last go around, we had an attestation by the qualified beneficiary that they were in fact terminated. They became eligible for COBRA due to an involuntary termination. There were some other requirements under the previous legislation that you had to meet. This may be the only requirement there. Contact information for the qualified beneficiary to contact someone to ask questions or follow up about the premium assistance. A description of this extended election period under kind of what I call the second bite at the apple opportunity. A description of the qualified beneficiary's obligation to notify the group health plan providing COBRA coverage of eligibility under another group health plan or Medicare. You should add that in there, or Medicare. A prominent description of the qualified beneficiary's right to premium assistance, including any assistance conditions at assistance. And then again, if allowed by the employer, a description of the ability for the employee to switch coverage options under the group health plan providing COBRA. So the timing requirement, the notice must be provided to the assistance eligible individuals and the second bite at the apple individuals by May 31, 2021. The DOL, along with the Treasury and HHS, must issue model notices within 30 days. There's also a new notice requirement that will be temporarily required. This will apply in circumstances where basically the assistance is ending because either the law is coming to an end, we're reaching September 30, 2021, or the individual has exhausted their COBRA period. So the law basically says is your requirements to provide the COBRA election notice, which remember, if you fail to do that, you could be subject to an excise tax of up to $100 per day under the Internal Revenue Code, and potentially $110 per day under EBSA if you fail to provide the election notice within 30 days of request. And so these election notices will not be satisfied unless you also provide a notice with the following, with information that the premium assistance will end soon and a prominent identification of the date it will end. And that the individual may be eligible for coverage without premium assistance through COBRA or underneath another group health plan. There's an exception to this notice requirement. It's not required if the premium assistance is going to be terminated due to eligibility for another group health plan or Medicare. Arguably, the qualified beneficiary is going to know that before the plan, so it's not requiring the plan to predict the future and provide the notice, this termination of assistance notice in those contexts. The notice must be provided no more than 45 days and no less than 15 days from the date that the premium assistance or the subsidy will end. And the departments will provide a model election notice within 45 days. Before moving on here, just to rehash what the departments did in the previous legislation back in 2009, is the Department of Labor issued 4 model notices. One was basically a revised election notice that include all the required information and would be required to be sent to qualified beneficiaries. And it appears to be all qualified beneficiaries, not just these these eligible assistance individuals, between the period of April 1 and September 30. a separate second bite at the apple notice that could be provided, a premium assistance only notice, and then 4, again, this alternative notice. So I would expect we would see something very similar. That doesn't mean you're going to have to provide everybody with 4 separate notices. I think there's some overlap there, and there may be some notices that are more appropriate for others. But again, probably some more guidance coming from the DOL on this area. So as I indicated at the beginning of my presentation, we are, those entities that fund the premium assistance will be eligible for a credit on their Medicare tax. This credit is refundable, so of course, if you're paying out more in premium assistance than you owe in Medicare tax, you will be eligible for a refund. It will be treated as an overpayment. There is an advance credit available, so entities may reduce their Medicare tax deposits in order to take full advantage of the credit. And the extent that you do that, and that generates a failure deposit penalty or failure to deposit, the failure deposit penalties will not apply to the extent that the failure was the result of the anticipation of a credit. These payroll tax credits are probably getting to be a little bit of old hat to employers, because they were basically how employers funded their share of emergency sick pay and emergency family medical leave under the FSA, and then the employee retention credits, under the CARES Act. So this is going to be another layer of tax credits that entities are eligible for. Just to clarify, this is also available to governmental entities, which was not always the case for some of those other premium tax credits under the FSCRA. These for governmental entities that have to provide these this COBRA premium assistance, like self-funded governmental employers, those governmental entities are also eligible for this premium tax credit. There's no double benefit, so the amount of the tax credit is essentially going to increase the entity's taxable income. And maybe at the risk of stating the obvious, you can't use the same amounts for purposes of an employee retention credit under the CARES Act under the CARES Act, or extended by ARPA, or a payroll tax credit for sick leave or family leave under the FFCRA. Finally, the statute of limitations, which is currently 3 years, will be extended to 5 years, but only with respect to credit amounts that are claimed under ARPA for purposes of providing the COBRA premium assistance. And again, the IRS is going to issue additional guidance. I don't expect this to be in the form of traditional regulations, which is fairly time-consuming. I expect some type of notice, probably with a series of FAQs, maybe some that are recycled from the guidance back in 2009. One thing to point out for employers that may be, again, subsidizing COBRA, again, as I pointed out, that may not be relevant to the employee, since they're going to get free COBRA anyway for a limited time period. But if you're subsidizing COBRA, for example, under a severance agreement, you're not going to get the amount that you're subsidizing is not going to be eligible for a premium tax credit. And I would be hesitant to basically go to the employee and say, hey, can we quick change your severance agreement? I'll throw you some more cash, and you agree to pay 100% of COBRA because you're going to get it free, and then we'll pay it for you, and then we'll get a premium tax credit. I wouldn't recommend that, but you can potentially, if you are charging less than the maximum COBRA rate, you can potentially change that, even though it's kind of in the middle of the determination period, and that increased amount, at least prospectively, will be eligible for the credit. But I think you want to be careful around those situations. One other thing for people that extend COBRA, to former employees as kind of a continuation of active coverage. If you don't treat that as what I'll call uncoordinated, or as coordinated with COBRA, you're probably not going to be eligible for a premium tax credit. So again, let me give you 2 examples. I have someone who's involuntarily terminated from employment. I say to that employee as an employer, I'm going to give you 6 months of COBRA coverage or continuation coverage as though you're an active employee. You only have to pay what you would have paid if you stayed here as an employee if you weren't terminated. And you after 6 months, the employer realizes 2 ways to treat that. They can either say at that point you can elect COBRA for the full 18-month period, or at that point you can elect COBRA and pay the full boat from there. But the 6 months I provided will be, credited against the 18-month continuation period. If you don't treat that 6 months of kind of employer continued coverage as being running concurrently with COBRA and kind of offsetting the 18-month maximum, you're not going to be eligible for a premium tax credit for your payments, that you were responsible for as an employer for extending that COBRA. So again, if you're not coordinating your extended coverage with COBRA, that is also going to impact the amount of the premium tax credits. I'm sorry, the tax credits that you're eligible for. Let me see if I can address, a couple of questions. First question: does the involuntary termination have to be occurred on or after 4/1/2021, April 1, in order to subsidy apply, or does it apply to any terminations occurred prior to April 1? Great question, because this is one of those subtle differences between how the law acts now and how the law acted in 2009. It is a termination the termination of employment did not have to happen after April 1, 2021. It could have happened at any point, and it's basically the premium assistance will apply to anybody that's eligible for COBRA, due to that involuntary termination of employment or reduction of hours in the period of April 1 through September 30. Again, a similar question: does the effective date of 4/1 mean only for losses of coverage after April 1, or does it apply to current COBRA participants? It's not just for coverage lost after April 1. So if I was terminated, if I was involuntarily terminated last August, and I enrolled in COBRA, my COBRA, and I'm still enrolled in COBRA, my COBRA is going to be free for me beginning April 1, 2021, and unless I have an otherwise event that ends that premium assistance early, I will be eligible for that free premium or that free COBRA through September 30, 2021. A lot of questions about that, so a lot of people are thinking that same thing. COBRA disaster relief notices required or optional. I think the question here is notification that was suggested in the DOL EBSA Disaster Relief Notice 2021-01. It is optional, but strongly recommended. If you go back, and we issued a client alert on this, I think on Monday, March 1, that is on our website, and it links to the actual guidance so you can read it yourself. The DOL suggests and says employers should, provide notice, and really think about it if they had provided earlier notice that is now, incorrect or inaccurate based on the DOL's updated guidance. You're strongly encouraged to send out notifications correcting that, or basically explaining that these benefit extensions or deadline extensions are only going to last for 1 year, a maximum of 1 year. If the outbreak period continues. Next question is whether you should use the new issued standard forms or should modify the forms you currently use. And I think, that is based on your, either one is permissible. I think, though, obviously if you use the standard forms, you may have to modify them to your own personal fact pattern or situation. Or if you use standard forms, I think you have to modify them to make sure that they contain the required elements that are added to the model form. So I think either way is permissible, but either way is probably going to require modification of the forms that you're currently using. Moving on with the ACA premium tax credit or premium tax credits. So what ARPA did is increase the eligibility for individuals who are eligible for a premium tax credit. So for those of you who are familiar with the ACA, that individuals are generally eligible when purchasing coverage through a health insurance marketplace to be eligible for a premium tax credit, which is basically a tax credit that helps the individual pay the premiums under its elected coverage. But currently, or under current law, you're only eligible for those premium tax credits if your household income is between 100% and 400% of the federal poverty level. ARPA for 2021 and 2022 tax years removes the 400% poverty level. So really, there's no upper end to when I could be potentially eligible for a premium tax credit. Now, one thing to point out is this does not basically, if you are offered coverage that is, minimum value and affordable from your employer, and again, that affordability is still based on 9.83%, and the affordability percentages are still based on 9.83%, you're still not going to be eligible for a premium tax credit. But if I were for someone, who's at 600% of the federal poverty level, maybe self-employed or not working at an employer that offers health insurance, I previously could have gone out and bought coverage on the exchange, but I would have to pay full cost. Now in 2021 and 2022, I will potentially be eligible for the premium tax credit for the cost of that coverage. I think the biggest way that this may impact employers is for those employers out there that are subject to the ACA pay or play penalty or the ACA employer mandate. Since the premium tax credit is the quote unquote trigger for penalties, pay or play penalties, this may also increase your exposure as an employer to ACA pay or play penalties in 2021 or 2022. Again, that is not the case if you are, an applicable large employer offering all of your ACA full-time employees coverage that's minimum value and affordable based on a affordability safe harbor. Again, in 2021, that would be 9.83%. Not going to impact you, but let's say, I am an employer that either, to a segment of my workforce or maybe to all my workforce, to avoid the huge pay or play penalty that basically treats me as I decided to pay rather than play. Let's say I just offer all my employees, minimum essential coverage. One of these skinny bare bones plans basically covers preventive care services only. And I know that, hey, if I have employees that turn that coverage down and go get a premium tax credit in the exchange, I may owe a penalty on behalf of that particular employee, and I'm okay with that. For those types of employers, this is going to have, be a real, real consideration, and that may increase because you may have employees that say, that are basically make too much money, whether it be from you or from a spouse's employer, to get a premium tax credit in the exchange because they were over 400%. Well, now in 2021 and 2022, those folks are going to be eligible for a premium tax credit, and since that premium tax credit triggers that pay or play penalty, that may increase your liability under the employer mandate as well. The ARPA law also increases the credit amount by basically offsetting the percentage of federal poverty level that you have to pay for coverage, again, that coverage that's obtained on the exchange. So on the left side of your screen, you have kind of the current chart. If you're at 300 to 400% of the federal poverty level, you need to pay, your cost of the premium will be 9.5% of your household income. Any premium in addition of in excess of 9.5% would be, covered under the premium tax credit. If you go to the right side, it's the sets forth the table, at least for 2021 and 2022 under the American Rescue Plan Act, and caps that amount at 8.5% of your household income. So obviously, as your household income goes up, you will be paying more for your coverage on the exchange, but again, caps that at 8.5% with any excess made up by the premium tax credit. The law does not require a repayment of an advanced premium tax credit that you received in 2020. So for those of you, again, that are familiar with how the premium tax credit works, there's really two ways you can do it. One is basically you can pay the full premium, and at the end of the year when you're filing your federal income tax return, you basically claim the credit, which is refundable on that federal tax return. Now, if you're not in a cash flow position that you can afford the full premiums during the year, you can be eligible for an advanced premium tax credit, which you get right away and reduces the cost of the premium, the insurance premium that you would have to pay. But when you get the advanced premium tax credit and you file your tax return for that year, you basically have to do a reconciliation and figure, hey, how much of that advanced premium tax credit was I eligible for? And if you got more than what you're eligible for, you arguably had to pay back the excess to the government. Now, to be honest with you, I'm not sure how aggressive the IRS was at chasing down those excess credits. If you were otherwise entitled to a refund, maybe that would offset your refund, but I'm not sure that they were really pursuing that. If you received an advanced premium tax credit in 2020 and it turns out you got more than what you had, the IRS, at least for 2020, is basically going to look the other way. You're not going to require to repay that. So even to the extent that it would potentially offset a refund that you would be entitled, it will not cause that. One surprising part is that the ARPA did not fix the so-called family glitch. Again, I think some people are probably familiar with this, and that's kind of the way that the premium tax credit works in connection with offers of coverage from an employer. So employees, including their spouse and dependent children who are eligible for coverage through an employee's employer, are not eligible for a premium tax credit if the employee is offered affordable minimum value coverage from the employee's employer. Where the family glitch part, though, comes in is affordability is based on the employee-only rate, not the family rate. So let's say, for example, I'm an employer that heavily subsidized my employees' employee-only rate, but for other coverage tiers, let's say I don't throw any employer money, and I say, hey, if you want to enroll in employee-only, I'm going to subsidize that. You pay $80 a month, clearly affordable under the federal poverty line safe harbor, no problem. But if you want to enroll in employee plus children, employee plus spouse, employee plus family, I'm not paying anything. You got to pay that entire amount. For a family coverage, that could easily be $1,400 a month. But because I was offered employee-only coverage at an affordable rate, and my spouse and dependent children are eligible for coverage from me as an employer, none of those folks were eligible for a premium tax credit if they went out and purchased coverage on the exchange. And the reason they call that a family glitch is, if I enroll all my spouse and kiddos in my employer's plan, and it costs me $1,400, that's not really actually affordable, in my sense of the term. So again, that's so-called referred to the family glitch. There was some talk about fixing that, and I still think that is on the legislative agenda, but that was not fixed in ARPA. You can, as an employer, kind of try to correct that yourself. You can exclude spouses and children from offers of coverage. But of course, if you're a large employer subject to the pay or play penalty, that employer mandate requires you to offer coverage to children. So if you're less than 50 employees, you may be able to exclude spouses and children and only offer employee coverage, which will open up spouses and children to eligibility for a premium tax credit if they otherwise satisfy the requirements. If you're over 50, you can probably only fix this with respect to employee spouses. Individuals who receive unemployment either receive or are approved to receive unemployment. If they purchase health insurance off the health insurance marketplace in 2021, they will be eligible for a 100% premium tax credit. Essentially, they are not required to pay anything for their coverage, purchased through the marketplace. IRS will issue additional guidance on this, maybe even just in instructions to the 2021-1040, but these individuals must provide self-attestation and potentially other documentation showing that they either received or are eligible to receive unemployment compensation. If you actually received it, that's probably going to be pretty easy because the government has to report that unemployment compensation as taxable income to the government. So, but if you're just approved and you never actually see it, you're still eligible for this 100% premium tax credit, but your obligations to show that you were approved may be slightly more challenging. Now, quickly wrapping things up, dependent care FSAs. The ARPA, for those of you that have a dependent care FSA, you know that employees are generally capped at putting $5,000 of salary reduction contributions into the dependent care FSA. If you're married filing jointly, the amount was half that, which is $2,500. For the 2021 tax year only, that amount goes up to $1,050, and again, it's half that if you're married filing separately at $5,250. So for 2021, it provides a lot more ability for individuals to save for dependent care assistance. And again, I expect the IRS to issue more guidance on how this is going to work in the context of a cafeteria plan. But the legislation does say that if you offer one of these dependent care FSAs or you offer dependent care assistance through an FSA that is a component part of a cafeteria plan, you can do a retroactive amendment to your cafeteria plan as long as you adopt that retroactive amendment by the last day of the plan year, which is in effect. So for a calendar year, you have to adopt that amendment by December 31, 2021. I think the retroactive amendment is welcome relief. A little bit surprising that the time frame is as tight as it is. Some of the other The Consolidated Appropriations Act, for example, gave you the ability to retroactively amend Section 125 plans, the last day of the calendar year beginning after the plan year in which the amendment took effect. So this is, this gives you some additional time, but it is potentially considerably shorter. With that, it looks like we have one other question. So, regarding retroactive COBRA elections, can someone elect COBRA retroactive just to April 1, 2021 to take advantage of the subsidy, or will they have to elect back to their original COBRA eligibility date and pay the premium? So again, I think that goes back to my slide where I talked about interaction with the EBSA disaster relief notices. And I think we're going to need more guidance from the Department of Labor on this. But the way that I interpret it, at least at this point, and I could be wrong, is if you are an eligible assistance individual, meaning you're eligible for this premium COBRA subsidy or COBRA premium subsidy, and you're kind of you had a qualifying event several months ago, and you just haven't elected COBRA, it's hanging out there, you still can do it, but you haven't elected it, and you say, hey, now I realize I can get free COBRA, and I elect it. Do I have to elect it all the way back to when when coverage basically ceased, or can I just elect it back to April 1 so I can only get free coverage? The way it appears at the second bite of the apple rule is that you can just elect it back to April 1. So these folks probably will be able to elect it, either back to, again, the date that was originally lost, which may require them to pay some premium, or back to April 1, in which case they would get it just for free. Again, I think we need additional guidance on the DOL, but at least that's how I interpret the rules working, at least at this point. A couple other questions coming in right now. Will plan sponsors get relief from the non-discrimination rules for dependent care FSAs as a result of the increased amount? This is a great question. Most of the people who would be able to contribute the amount will likely be higher wage earners and might make a failed testing. This is a great question. So for those of you that have dependent care FSAs and actually run non-discrimination testing, you will know that one of the hardest tests for employers to pass is the average benefits test, and basically, or the 55% average benefits test, and it basically says that non-highly compensated employees' benefits under a dependent care FSA have to be, the average benefit of non-highly compensated individuals under dependent care assistance FSA must be at least 55% of the average benefit under dependent care FSA for highly compensated employees. And this is problematic for a lot of employers to pass. And as this question points out, it's more than likely that those highly compensated employees, which for this purpose is anybody making more than $130,000 a year, they're more likely to drop money into that dependent care FSA in addition to the $5,000. Unfortunately, the legislation does not discuss this at all. It gives no relief to the non-discrimination rules. Now, whether the IRS provides some type of relief remains to be seen. I'm optimistic they would at least address this. I am totally clueless on whether they would provide non-discrimination relief. If you look at the most recent notice that came out, 2015 or 2021-15, which addressed FSA changes allowable under the Consolidated Appropriations Act, there was very limited relief from non-discrimination requirements. There was some, but very limited. In fact, several provisions said, hey, you can make this change, but and you can make it only for some people, but it still needs to comply with the non-discrimination rules. So that's a great question. Unfortunately, I just don't have an answer at this point. Next is the COBRA subsidy available to anyone involuntarily terminated, even if it was non-COVID related, such as performance or misconduct termination? So another great question, and there's a nuance here, right? So there's no condition that your termination result from anything related or even tangentially related to COBRA. As long as you became a qualified individual because of your involuntary termination, you're going to be an assistance eligible individual. Now, the question goes on to say such as performance or misconduct. Remember, there is an exception to the obligation to offer COBRA if someone is terminated for their gross misconduct. So if you've got someone that was terminated for performance issues, yeah, they're going to be they're going to be eligible for the COBRA premium subsidies. If you have someone that you think it was terminated for gross misconduct, which, you know, that's a facts and circumstances based test, and different rules apply in different areas of the country because they've been interpreted by courts differently, then arguably not only you don't have to provide COBRA, so they're certainly not going to be eligible for a COBRA premium subsidy. But just as you would have done in the past, if you're going to not offer someone COBRA that was terminated and you believe it was gross misconduct, you're probably going to want to talk to your legal counsel about that, because if you get that wrong, they can come back after you for that required COBRA coverage. And if they're successful, you're going to be providing that coverage potentially without the protection of insurance or your stop loss insurance if you're already self-funded. You know, and the folks that are most likely to come after you for that are those ones that, you know, incur significant medical bills that would otherwise be covered by COBRA. So again, you know, the involuntary termination doesn't have to have anything to do with COVID. And if you're not going to offer COBRA due to the gross misconduct exception, I think you're going to want to have conversations with legal counsel before you make that decision. With that, it looks like we have all the questions. I want to thank everybody for joining us this morning. Please log back on tomorrow morning at 8 a.m. as my partner, Eric Daly, I believe, will be addressing some SBA issues that are covered under the American Rescue Plan Act. With that, I think we're all set. Everybody have a great day. Thanks again for joining.